Your heart is pounding. The red and blue lights swirl in your rearview mirror, a disorienting kaleidoscope of dread. Or perhaps the knock at the door comes late at night, firm and official. Or you're just in the wrong place at the wrong time, and a detective slides into the seat across from you in a sterile, small room. The officer is polite, maybe even sympathetic. They say they just want to clear things up to get your side of the story. They have a question, one that seems innocent, logical, even helpful to answer. It's a question that has broken countless people, unraveled defenses, and turned seemingly minor situations into life-altering convictions. As a legal professional, I am telling you with utmost urgency, there is one specific question above all others to which you must never, ever say yes. This article is not a work of fiction. It is a procedural map of the modern criminal justice system, where the most critical battle often occurs not in the courtroom, but in the initial conversation with law enforcement. Your words, more than any piece of physical evidence, will be used to construct the case against you. The system is designed to extract those words, and it is masterful at doing so. We will dismantle the psychology of interrogation, the law that governs police questioning, and the stark reality of what happens when you unknowingly surrender your most fundamental right. This is not about guilt or innocence. This is about understanding power, strategy, and survival within a complex legal architecture. By the end, you will know the question, understand exactly why it is so dangerous, and possess the simple, powerful phrase that can shield you. The landscape of power. You are not having a casual chat. First, we must eradicate a fatal misconception, the belief that a police interview is a collaborative search for truth where you can talk your way out of trouble. It is not. From the moment a law enforcement officer decides to focus on you, the dynamic is inherently adversarial. Their job is to gather evidence to support an arrest and a conviction. Your words are evidence. Period. Even if you are innocent, especially if you are innocent, you operate under a catastrophic disadvantage. You believe in the just world fallacy, that the truth will simply reveal itself. The officer, however, is trained in Reed technique-derived methods, a system of interrogation focused on behavioral analysis, theme development, and overcoming denials. They are trained to interpret nervousness as deception, a pause as fabrication, a correction as a lie. Normal human reactions to the immense stress of being questioned by authority become, in their report and later in testimony, indicators of guilt. The environment is controlled. They may offer you a beverage, appear relaxed, and suggest they're your only chance to tell your story before things escalate. This is a tactical disarmament. The goal is to elicit a narrative, any narrative, that can be dissected, contradicted by later evidence, or used to establish elements of a crime. A simple, innocent misstatement about a time, a location, or who you saw can be later characterized as an intentional lie to cover guilt or as consciousness of guilt. The Pillar of Liberty, the Fifth Amendment, and Miranda versus Arizona. To understand the pivotal question, we must anchor ourselves in the Constitution. The Fifth Amendment guarantees that no person shall be compelled in any criminal case to be a witness against himself. This is not a loophole for the guilty. It is a foundational right for everyone, designed to prevent the state from using its overwhelming power to force a confession, true or false. The practical application of this right comes from the landmark 1966 Supreme Court case, Miranda versus Arizona. The court ruled that to protect this right, prior to a custodial interrogation, police must inform a suspect of certain rights. The right to remain silent, that anything they say can be used against them, the right to an attorney, and that if they cannot afford one, an attorney will be provided. These are the famous Miranda warnings. Crucially, Miranda rights are not always required. They are only triggered during a custodial interrogation. Custodial means a reasonable person in your situation would not feel free to leave. A traffic stop is considered a temporary detention, not full custody. A knock and talk at your home where you are free to close the door is typically not custodial. But the moment the interaction shifts, you are moved to a squad car, to a station interview room, or an officer's tone and language imply you are not free to go. Custody may have begun. Interrogation means any words or actions the police should know are reasonably likely to elicit an incriminating response. This gap, The non-custodial, pre-Miranda conversation is where the most dangerous games are played. Officers are taught to investigate first, to gather statements and evidence before an arrest is made and Miranda is read. Anything you say during this pre-custodial phase is almost always admissible. They want your story locked in before you have a lawyer or even think about silence. The architecture of a trap, how questions are weaponized. Police questioning is a sequential funnel designed to move you from comfortable denial to damning admission. It often follows a pattern, the rapport building open. How's your day going? That's a nice car. Take care of it? This lowers guard. The open-ended narrative. So tell me what happened. They want a broad story to mine for contradictions. The progressive specificity. They zero in on details. What time exactly did you leave? Which route did you drive? Did you see the red light? Each answer narrows your escape routes. The confrontation. When they find an inconsistency, or allege one, they present it. But your phone records show you here at that time. Why would you say you were there? The goal is to fluster you into a new, compromising explanation. The theme development. They offer morally or legally minimizing rationales. Maybe you just had a few too many drinks and didn't mean to hit him. Maybe you took the money because you were desperate for rent. That's understandable. They are selling a confession as the easier, more sympathetic path. The alternative question. This is the classic. Did you plan this for weeks, or did it just happen in a moment of passion? Both alternatives admit guilt. They just argue over the degree. Throughout this entire process, every question is a potential trap. But one question stands supreme because it is the master key. It is asked not at the climax, but often at the very beginning. It is the question that, if answered affirmatively, voluntarily dismantles every defense you have before you even know you need one. The question, do you mind if I ask you a few questions, or its deadly variants? Here it is, in its deceptively simple forms. Do you mind if I ask you a few questions? Would you be willing to help us clear this up? Can you just tell me what you saw? Will you come down to the station to give a statement? It'll only take a minute. Why is this the question you must never say yes to? Saying yes is not merely answering a question. In the eyes of the law, it is a voluntary, intelligent, and knowing waiver of your core constitutional rights. You are waiving your right to remain silent. You are waiving your right to have an attorney present. You are waiving the protection of Miranda before it's even offered. You are transforming the interaction from a police investigation into a consensual interview, and everything you say after that yes becomes rock-solid evidence against you. By agreeing, you have consented to the interrogation. You have removed any later argument that you were coerced or that the questioning was custodial. You showed you were free to leave by not leaving and willing to talk. Assumed the impossible burden of perfection. You are now tasked with telling a story that must perfectly align with all unknown physical evidence, digital records, and witness statements the police have or will obtain. One slip, a wrong time, a forgotten detail, becomes proof of deception. Given them a blueprint for your cross-examination. Any statement you make will be used to lock you into a version of events. If you later testify at trial differently, the prosecutor will eviscerate you. But on the day of the incident, you told Officer Smith this. Why is your story different today? Were you lying then, or are you lying now? Potentially incriminated others, and thus yourself. In trying to be helpful, you might say something that implicates a friend, a family member, or an acquaintance. This gives police leverage to pressure them, who may then give a statement against you to save themselves. Imagine this scenario. There was a burglary in your neighborhood. An officer knocks. Hey, we're checking on a break-in. Do you mind if I ask you a few questions? You, wanting to be a good citizen, say, sure, no problem. You say you were home all night. They ask if you saw anything suspicious. You say no. They ask if you ever go for walks in the area. You say, oh yeah, I walk my dog every evening around 9 p.m. They thank you and leave. Later, they get security footage from a neighbor's camera showing a figure with a dog near the scene at 9:15 p.m. Your innocent, cooperative statement has just made you the prime suspect. Your alibi, I was home, is contradicted by your own words, I walk at 9s. The helpful statement became the center of the case against you. So what do you say instead? You must be polite, clear, and unequivocal. You say, Officer, I respect what you do, but I choose to remain silent. I want a lawyer. Say it. Then stop talking. Do not explain. Do not apologize. Do not offer a just one thing. Silence is a complete sentence. Asking for a lawyer is an inviolable command that must cease all questioning. The psychological onslaught and how to withstand it. They will not like this, expect a shift in tactics. They may say, "Why do you need a lawyer if you've done nothing wrong? I'm just trying to get your side. This is your only chance to tell me what happened." If you don't talk to me now, things will get a lot worse for you. I can't help you if you won't talk. You're making yourself look guilty. These are all pressure plays designed to provoke fear and reverse your rational decision. Remember, needing a lawyer is not an admission of guilt. It is an exercise of wisdom. Innocent people are convicted every year based on their own misunderstood or mischaracterized statements. It is never your only chance. Anything truly important can be said later, through your attorney, in a controlled setting. Things get worse for people who unknowingly confess or contradict themselves. The only way to make it better is to stop the flow of self-incrimination. Looking guilty to an officer trying to interrogate you is irrelevant. Looking convicted to a jury because of your own taped confession is what matters. Here is a suspense-driven question for you to consider. What if the officer says, "Okay, you're free to go," but then follows you, pulls you over a block away, and asks the questions again in a traffic stop setting? Have you just avoided the trap, or has it simply been reset? The answer lies in the persistence of the investigative intent. The second interaction is likely still custodial or a continuation of the first. Your response must remain the same. I am remaining silent. I want a lawyer. Do not be fooled by a change of scenery. The real-world consequences. A case study in words. Consider the case of Salinas versus Texas, 2013. Genovevo Salinas voluntarily agreed to go to a police station for questioning about a murder. He was not under arrest and was not read his Miranda rights. He answered questions for an hour. When asked if ballistic testing would match his shotgun to shell casings from the scene, he remained silent, looked down, and shuffled his feet. He later refused to answer further questions. At trial, his silence and demeanor in response to that specific question were used as evidence of his guilt. The Supreme Court, in a fractured opinion, held that because he had voluntarily submitted to questioning and had not expressly invoked his Fifth Amendment right, his pre-Miranda silence could be used against him. This case is a chilling masterpiece of the peril of voluntary cooperation. Had Salinas invoked his right to silence and counsel before answering any questions, neither his answers nor his subsequent silence could have been used. By agreeing to talk initially, he entered a labyrinth from which there was no safe exit. The unified theory of self-preservation. The rule is absolute and simple. Any encounter with law enforcement that moves beyond basic on-scene identification, like during a traffic stop, providing license and registration, should be met with a polite, firm invocation of your right to remain silent and your right to an attorney. This applies to traffic stops. Beyond providing documents, you are not required to answer, "Do you know why I pulled you over?" or "Where are you coming from tonight?" "Officer, I am remaining silent." Street encounters. "Can I ask you a few questions?" "I am choosing to remain silent." Station requests. "Would you come in to help us?" "I will not answer any questions without my lawyer present." Executing a search warrant. Officers have a right to execute the warrant. You have no obligation to answer questions while they do. "I am remaining silent. I want a lawyer." Your words are your own. Once released, you cannot control how they are recorded, interpreted, or used. The only way to maintain control is to retain them. Conclusion. The power of a single word. The criminal justice system is a machine fueled by information. Your cooperation is its primary energy source. By refusing to power it with your own words, you force it to work on its own steam, to build a case with physical evidence, forensics, and witness testimony, all of which are subject to rigorous challenge by a defense attorney. You level the playing field. The question, "Do you mind if I ask you a few questions?" is the gilded invitation into a chamber where the rules are stacked against you. "Yes" is the key that turns the lock from the inside. Do not say it. Let the powerful, protective words be yours instead. I am remaining silent. I want a lawyer. It is not just legal advice. It is the most important survival skill you can possess in the modern world. If this detailed breakdown has reframed how you view police interactions and shown you the critical importance of protecting your rights, ensure you never miss crucial information that could safeguard your freedom. Subscribe to the channel now for more essential legal education and analysis.